Welcome aboard, everybody. Thanks for coming out, folks. I guess the lecture series is wrapping up real quickly here. And next week, unless I dig someone up, the lecture will be about the social impact of prohibition. And I really hope to dig someone up, and there's a good chance that I will, which would mean today's my last lecture. If I do my job right, I'm going to have Jeremiah come over from Cannabis Culture in 2 weeks from now. He doesn't even know it yet, but I'm sure he won't turn down the chance to come over and have some fun with us. And 3 weeks from now is going to be the MMAR, and I'd like to get Mick Mann to come from Up Island to teach that one. And the final lecture this semester is on Hempology 101, and Kristen's going to come from the club to teach that. So I'm looking forward to the rest of the semester, and I just need to get to work to line everyone up to do that. A quick note, I'll remind people at the end, but there's a meeting next Wednesday at 4:30 put on by a new club. I've not heard of the UVSS Harm Less Club, Harm Reduction Club, that's now on campus.
There'll be some guys. I only went to one meeting though because of my time schedule. So I got the impression they're busy.
It's so neat that I'm doing a lecture on the social impact of prohibition 1 hour before they're having their meeting next week. But I've not heard of them. I get the sense they're quite new. But at the Michael Pajowl room, do you guys know where that is?
It's in the student union building. It's that building that's like right at the front there where they put all the stuff on pump stand.
Okay, sort of the big cafeteria space going into the sub-building. Thank you. Cool.
They were actually here last time. Oddly enough.
They were where?
Here.
Okay.
Last meeting. It was a little weird.
Cool. Well, I hope to jump in after 4:20 next week and participate myself, but I might try and dig someone up from this group to come and help teach the lecture beforehand as well. But anyway. So today's lecture is on cannabis and the law. I guess something I'm all too familiar with. I think for today's lecture, I'll try and stick with Canadian law, building up to where we are now, both for personal use, recreationally, and medically. A lot of the nuances in law now are around what is medical, and certainly a big focus of our lecture series. But I would like to start with recreational. I guess I'm going to focus on court cases as opposed to the politics of the law and its development. The background of that starts with the Controlled Drugs and Substances Act, which I believe came into effect in 1997. It was essentially a rewrite of the Food and Drug Act and the Narcotic Control Act, which had overlaps in different ways. So they essentially scrapped those two pieces of law and put the CDSA together. And the other, and so when we refer to criminal law, it's all been essentially enacted in that year. But when you read the Martin's Criminal Code, I didn't even think to bring one, there's two parts of it that are critical. There's the written letter of the law, and then there's the interpretation in court, which is often more important than the written letter. And when you go to court, if you get challenged, and I guess I'll start with the Randy Kane case. Randy Kane was caught basically smoking a joint with a buddy in a car over in White Rock back in, what was it now, even like 93 maybe? Something like that, 92 or whatever. Randy got charged with possession. Well, Randy was one of the nicest guys in the movement that I've met, honestly, over in the Lower Mainland. He's a very hard-working man and was outright disgusted at the idea that he would be charged and it would have such a big impact upon him. He works in the film industry, so possession charge means you can't travel across the border. Luckily, there's enough people in the Lower Mainland that didn't matter. It wasn't a big wheeler dealer. He was smoking a joint with his buddy in the truck. So he hired John Conroy, and John used the Charter of Rights and Freedoms to argue that the law was flawed because it essentially violated Section 7 of the Charter of Rights and Freedoms, which is supposed to protect our security of the person, and the harm principle was what was the main argument of the decision, or of Randy and John's position, which is essentially that the law causes more harm than the actual use of the substance. And so they tried to persuade the judges of this. I believe, Randy lost in the lower court decision. He appealed that decision, and 1 out of 3 judges of the BC Court of Appeal agreed with their position that in fact the harm principle they ruled, I think, was a fundamental principle of justice as opposed to just a principle of justice. It's funny, the nuances in law, but according to the Charter of Rights and Freedoms, which is really more important than the CDSA here, what the judges do is essentially they look at the written law, they look at the facts of the case, and then they weigh that against the Charter of Rights and Freedoms to determine first whether a person's rights have been violated, and that violation can occur in any section between 2 and 15 of the Charter. Beyond Section 15, it's not so much criminal, but think more about language and things like that. But anyway, the first 2 sections, 2 to 15, are more about criminal law, security of the person, arbitrary arrest and detainment, these sorts of issues. Discrimination 15 is sort of discrimination. There's and so if you're charged with something, you have the ability to invoke any one of those sections to say that your rights have been violated. And the first thing you need to do is prove that. So Randy not only proved to one of these 3 judges that his rights had been violated, but the test that the courts in Canada use to determine whether it's in the public interest to violate a citizen's rights is Section 1. And Section 1 of the Charter of Rights and Freedoms states that the government can, to protect public security, public peace, and public order, essentially, violate other sections of the Charter and people's rights if it is in the best interest of the public to do so. And so there's a sort of balancing act that the courts often do when they determine whether a person's rights have been violated. It may mean that that individual gets the charges thrown out or a lighter sentence, but often, and unfortunately increasingly so, Section 1 of the Charter is used to maintain the status quo, even though an individual's rights may be getting violated by the law. And so Randy Kane fought this. Now, that decision was joined up with Chris Clay, hemp store owner in London, Ontario, who in the mid-90s went all out. And I'm trying to recall, Chris had plants in his store, I think, even when he got busted. I think it was more than simple possession. He went into a big public relations campaign with this court case. That was the intent. He came up with the great campaign of selling what he called hemp bonds, which is kind of the precursor to our Cannabis bonds. He raised about $25,000 to pay Alan Young, his lawyer, to argue. And I think, again, though he lost at the lower court in front of one judge, he fought it and got in front of 3 judges, and 1 out of 3 judges again agreed that the harm principle was in fact a fundamental principle, which essentially means instead of a principle of justice, which many of the sections of the Charter are, a fundamental principle is one that just cannot be broken. If the fundamental principle of justice is violated, then Section 1 of the Charter, doesn't hold as much weight. Anyway, yeah, Chris Clay fought, and the other individual, David Melma Levine, got caught selling pot over in Vancouver, and he argued himself. Again, 1 out of 3 judges in the provincial court of BC, the Court of Appeal, agreed with him, and those 3 cases were bound together and got before the Supreme Court of Canada in December 2003. A decision came down essentially admitting the harm principle was an important principle of justice, but stated that it was in the best interest of the public peace and public order to keep these laws on the books. And it was not a unanimous decision. I believe it was a 6-3 decision at the Supreme Court of Canada, which is actually pretty close. 2 more judges on our side, it would have been 5-4 our way. So in a lot of ways, the argument that the harm principle is a fundamental principle or an important principle of justice has some validity to it. And it's unfortunate that judges have brushed aside any arguments against the possession law since then, with the idea that the Supreme Court of Canada made up its mind and that's how it is. There wasn't as much science presented in this case as I would have liked in certain areas, and it came back later, and the science is developing, so I'm not really blaming the lawyers or defendants at all. It's more the scientific community that needs to pick up the right research and work with us here. Because the Supreme Court identified 5 vulnerable groups as being those that they were trying to protect with this law. And essentially, if it weren't for these 5 vulnerable groups, the Supreme Court wouldn't have very much weight to stand upon, because they recognized that essentially for the average healthy person, the law caused far more harm than good. But they decided in the best interest of pregnant women, youth, addicts, people with mental health issues, and people with other medical problems needed protection somehow by prohibiting this plant. Now it's counterintuitive to think that any of those groups are going to be protected by the prohibition of cannabis. Pregnant women, for example, are strongly advised against using any kind of drug when they're pregnant. My understanding is the only women that would use cannabis when they're pregnant would use it very sparingly to help with their own medical issues, so they don't have to take drugs, so that they can eat and sleep, so that the baby can grow healthy and happy. And my understanding in studies done in Jamaica and in particular, Jamaica and India, where there's generations of cannabis users, there is no negative impact perceivably upon the youth of moderate cannabis users or pregnant women. So on one hand, there aren't doctors prescribing cannabis to pregnant women. It's not a perceived public health issue. And in general, if a woman is choosing to use it for her health during pregnancy, well, that should be between her and the doctor. And having criminal law involved in that decision is unfair. And again, that goes even for people with compromised medical problems, right? Like heart problems and stuff. The court somehow thought that they could intervene, and the courts would determine by criminal law what should be accessible or what's not. When people have serious medical problems, they can determine what to use or not. the idea of using criminal law power to stop youth from using cannabis is just completely the opposite of the reality that I grew up. One of the first things that I did as a young person was to sell some hash to my buddies so I didn't have to pay as much for it. And otherwise, a lot of young people get involved in the cannabis trade at a very early on, in part because there are no legal jobs for adults to do it. And by the time most people get a job and a house and a home, they don't want to wheel and deal, and for various reasons, youth end up, I think, getting drawn into the drug trade and into drugs and problems because of the prohibition. And I would suggest there's very few youth that haven't tried cannabis because of the law, and in fact, it's quite the opposite. So I would argue that we would need a lot more research around youth and cannabis in different ways. But the idea that you're protecting addicts by keeping it illegal, to me, is just completely absurd. These people are willing to do very hard drugs and go to some very extreme lengths to get them, and to suggest that stopping them from using cannabis is a benefit to them is quite absurd to me. We should be giving them as much as they can eat so that they don't go and steal anymore. It would save our communities a lot of money if we did stuff like that. So the vulnerable groups that they identified, and people with mental health issues were included in medical problems. And my understanding is people with mental health issues, generally speaking, determine which drugs they use when they want. There are some medical issues where people get withdrawn and don't go into public at all, and they might not have access to cannabis. Like, there's some people that we work with that are just extremely isolated. I did a delivery to one guy a few months ago, just over in Esquimalt, an apartment. I think he had been out of his apartment 5 times in the last 10 months before that time period. Some people with mental health issues just don't go anywhere. But I would suggest that none of those people that want to use cannabis wouldn't have access because of the law. Again, quite the opposite. They would have access to not only cannabis, but any drug that they so choose to deal with their mental health problems. So anyway, without some science really proving that those vulnerable groups are hurt by the drug laws, it's going to be really hard to overturn the Supreme Court of Canada's decision here. But I firmly believe that if they're investigated, it would be shown that all these various communities of people would be hurt by it. Anyway, I've tested these laws. When I got busted up here at Evict in my cookie giveaway, I used the harm principle myself in my constitutional challenge. And I thought it was a pretty good argument. The harm of giving out cookies was less significant than the harm of being busted giving out cookies. But I tagged my court decision onto the Melville Levine decision, and then essentially had to argue against the Supreme Court of Canada, which wasn't very easy. But there are some flaws, I think, in the possession laws that can still be challenged around the harm principle. But it is something that these laws are likely to stand until we see decriminalizing or other more open political maneuvers. It might be a very long time before the courts are going to strike down the possession and or other related trafficking and cultivation laws for recreational use. But on the other hand, there's medical. Oh boy, damn. A lot of the developments in law in the last decade here in Canada have certainly been around medical issues. And it was the Parker decision that opened up the MMAR in 2000, and the Parker decision is really critical to this day. It was a very well-written decision by the Ontario Court of Appeal in regards to a man with epilepsy who had been able to prove with his doctors that the drugs that he was being given weren't nearly as beneficial to him as the use of cannabis, including synthetic THC, which is ironic because Dr. Harold Callant, who's still like the top researcher at Health Canada, because they've gutted their research department here, so they've got like a 84-year-old scientist with nobody doing any research in the department as being their kind of head researcher. Anyway, Dr. Callant back in 2000 essentially testified to the benefits of plant-based synthetics, acknowledging that synthetic THC had severe limitations and that it could in fact have side effects that normal THC doesn't have. Synthetic THC, for example, can cause severe anxiety in people, and there's a number of, I guess, other problems that can result from it. Anyway, when Health Canada created the MMAR, though, they just made cannabis, marijuana legal to grow and possess, but never included any of the derivatives, cannabis resin, THC, CBD, CBN. And so back in 2002, 2003, we went through 4 police raids in our store. And when we went to court the first time, I was able to argue, along with the Morgentaler and sort of Parker decision, that I had a moral duty to provide medicine to vulnerable citizens, that had a constitutional right to medical self-determination. So people had essentially chronic pain. This is what we looked at with the case law earlier with Morgentaler, was that if a person had a medical necessity, they have a constitutional right to determine their course of medical treatment. And I essentially used the Morgentaler decision to defeat the first charges. Ironically, the second trial, we were also charged with trafficking in cannabis resin, not knowing that it was not included in the MMAR at the time, and we weren't prepared for it in court, and we lost. I was quite upset with not only the Crown for the surprise and the judge for the bad decision, but even my own lawyer. So I wrote the appeal myself and filed a factum spelling out the reasons that the derivatives of cannabis resin, THC, and the like, should be included in the MMAR, that people should be able to make their own medicines from this plant and not be forced to smoke or eat the entire plant itself, and that they could make massage oils for their skin and other edible products and extractions, that should be legally available to people, especially, well, for medical purposes. Anyway, and other individuals like Watermelon were actually charged with selling cannabis resin and cookies, and she won her court cases as well. Actually, that helped set up some of my work. However, my cookie trial, I was originally charged with trafficking THC, and I was originally charged with trafficking cannabis marijuana, and then they changed that not to cannabis resin but to THC, and I was convicted by a jury of trafficking in THC because it was shown that cannabis or THC was available. It was in the plant, in the cookie, so it tested positive for it in the laboratory. And according to the laboratory standard operating procedures, THC just has to be there. They don't have to prove the percentage of it. And I tried to argue the cookies had such a low percentage of THC that they were in fact a hemp food, a health food product. They would get people high, was what I tried to argue. Well, they wouldn't buy that argument. I was convicted by a jury after a 5-day trial. It was quite an interesting learning curve for us. But yeah, I was convicted of trafficking in THC. And it's sort of come around full circle now, because a year and a few months ago, our bakery was raided in the downtown apartment for the Cannabis Buyers Club. And my friend Owen was charged with trafficking in cannabis and trafficking in THC for making the food and skin products. And trial is going to start this May. The bulk of the constitutional trial is going to be this fall. But we are going to argue that THC and cannabis resin and CBD and CBN, again, these derivatives, if you would call it that, of the cannabis plant, should be included in the medical marijuana access regulations. There's no reason that people shouldn't be able to make hashish or butter without the raw plant still being in it. And so we are going to use Dr. Harold Gallant if he's available. You know, we want Health Canada's researchers to come out here and explain why it is that THC is not available to people in medical need. I don't want to get into all the nuances of our arguments here, but it is a really important case to a lot of people because, as I mentioned, synthetic THC is legally available. It's $8 a pill, and it's being sold around Canada, and it's not something that is nearly as beneficial as a cookie is. I'm convinced of that, and the science is coming out in support of that. And so I think a lot of what we're trying to prove in court does come down to the science. We need good evidence, and it's been very frustrating to do that. Honestly, there's no peer-reviewed journal in the world that focuses on the cannabis plant right now. Any that did exist have stopped, and it's really hard to get any publications through a peer-reviewed journal on smoked cannabis at this point. Drug companies are quite interested in promoting synthetic derivatives, and other sort of social studies are often being done, but there's very little plant-based research being sponsored around the world. It's mostly around other marketable products instead of things that people can make easily in their own home. And so we think it's a really critical case. And there's a lot of other court cases that are coming up that will hopefully strike down other sections of the medical marijuana access regulations. It's been a completely flawed set of rules since the very beginning, and the results have been in some ways quite dramatic, but in other ways the program itself has been so dysfunctional and kept people distracted from growing and providing medicine at times that I can't wait for it to be undermined and struck down in every way possible. But yeah, there's a lot of trials that are coming up this year. There's been clubs busted in Montreal and sorry, all over Quebec and Ontario. So it's going to be a very important year for people in the courtroom here. Much what else to say. Are there any questions?
Do you think we'll ever have cannabis legalized on a level like where it's alcohol? This where you go into a store and buy it like without medical purposes?
Oh, I have no doubt of that now. Yeah.
Yeah.
It's more a matter of when.
Okay. Well, like where is our government at right now in that process of legalizing it? Like, are we still fighting?
Well, the Conservatives want to throw us in jail, right? So the people in charge of the Canadian government, luckily they're a minority and don't have full control, or they'd be pushing S10 through. And so unfortunately, we're going backwards here right now. The Conservatives, although the Canadian populace itself is becoming more open, more accepting. There's businesses and people popping up. So the industry is quite exploding. So despite our government, we're really finally, busting a move in all sorts of ways with hemp and cannabis. Sort of reefer madness doesn't have the control that it used to. So, in a lot of ways, our fortunes, like it or not, depend on how fast it goes in the United States. They're ahead of us right now. Washington State is having a huge debate about legalizing cannabis and selling it in stores, liquor stores, just as you stated. There's senators in support. The Seattle Times just came out in support of legalizing cannabis, and the DEA is actually sending people, I think this week, from Washington D.C. to put the Seattle Times in its place. But yeah, there's a real huge momentum down there in various states. You know, not all states yet, and I think globally as well. You know, there's a lot of changes that are occurring that will put pressure on the states to fold. Until we see a liberal minority government, it's hard to imagine a decrim bill being passed. The Liberals have said they put a decrim bill back on if elected, and if the Liberals and NDP got enough to get bills passed, at the very least, that would likely happen fairly quickly. But when the Liberals are going to have a minority government again in this country is hard to speculate. I hope sooner than later. But yeah, this is why I say, like, when it comes to recreational use, we're probably going to lean more towards the politics in Canada.
Yeah.
When it comes to medical and expanded medical rights, it's more likely to come through the courts. Even when the Liberals were in charge of the MMAR, they had it completely back-asswards. Like when they first had the program going, they set up a grow-op to do research, and none of the MMAR card holders were going to get access to that. Like, they had to fight in court for people that couldn't grow their own to get it from Flin Flon. Then they found out how bad it was. But yeah, the program has been completely dysfunctional from the beginning, that's for sure. So, like I say, the MMAR we fought in court.
Didn't the Prairie Plant Systems in their production center move to Saskatoon recently out of the mine?
Yeah, they've been really secretive about it, but it's like, you know, as high a level of security as you need for like a nuclear reactor.
Oh, they have one there too.
It's right beside the nuclear reactor, yeah, no doubt.
Problem.
Okay, well, thanks for coming in, guys. Like I say, hopefully this is my last lecture of the year. I'll try to line up folk to at least help me next week, and then get one guest speaker after another. So thanks everybody for coming out. Have a great day.